Is the state neutrality an excuse for an indirect discrimination against religious minorities? Does a secular state like France has the right to prohibit all believers to wear religious symbols or clothing in public sphere? Does a formally secular state like Turkey has the right to refuse and demand for exemption from the general protective measures concerning the use of historical monuments? Your Eminence, Dr. Liberakis, ladies and gentlemen, in the next 4 minutes I will argue that religious minorities enjoy, in certain circumstances, the right to demand exception from neutral provisions, or, let's say, general measures. Well, in my view, there is a clear distinction between the first and the second example. In the case of headscarf in France, the question concerns rather the innermost conviction of the individual, the readiness and urge to realize faith, than the classical manifestation of conviction, like place of worship, education, etc. And in this context, in the context of the innermost conviction, there is no room for neutral limitations. I know that it sounds a little bit strange for Orthodox or Catholic Christians that clothing is a part of innermost conviction, but I shall stress that for other religious communities, like Sikhs, Buddhists, Orthodox Israelis, religious faith is equivalent to symbolism, clothing, specified living conditions, like nutrition, sacrificed nutrition, contact with earth and water, and in general, to everyday behavior. In this view, modern European human rights law is ready to crystallize this modest and realistic at the same time approach of religious freedom. 3 years before, in the case of Ahmet Aslan and others versus Turkey, the applicants, all members of a religious group known as Ancimenti Tarikati, complained of their convictions in 1997 for a breach of law on their wearing turban, baggy trousers, a tunic and a stick. The European Court of Human Rights found a violation of freedom of religion. Last week, the plenary of Strasbourg Court examined the complaint of a practicing Muslim women wearing headscarf in public places in France. I'm rather sure that the plenary's judgment will confirm the Ahmet Arslan case law. But there are cases where religious neutrality may take precedence over the right to manifest one's religion. And this is my second example, the use of historical monuments. At first, it is acceptable for the needs of collective manifestation of religious beliefs to give a permission to a religious group to use a known place of worship. In this specific manifestation is not opposed to public order. This was the case of Soumela Monastery in Trabzon. Once per year, a few believers in an area where no other place of worship exists for Orthodox Christians. But state authorities have the right and the duty under neutral and general provisions to protect any big or small historical monument which is located near several other places of worship. In other words, the Muslim majority cannot ask for an exception from the general prohibition to use Hagia Sophia because, firstly, they can pray in several other mosques just near Hagia Sophia. Secondly, because Muslims believers are not 1,000 or 2,000 believers people, but millions, and they are bound to cause damage to the building. And finally, because there is a historical tension between the Muslim majority and the Orthodox minority concerning the use of the monument. And this is a very significant public order reason for denying the use of the monument for the reasons, for the needs of the worship. In conclusion, by adopting neutral constitutional provisions, the majority doesn't satisfy the requirements of freedom of religion of minorities. The modern European perception of religious freedom demands from European secular states to focus to certain exceptions from general neutral measures. One is the example of the heterograph, but there is no doubt that this is not the case of the religious views of historical monuments by the religious majority in a certain state. Thank you.